Did you know that the mortgage institution will not release the title with just one signature? What are we talking about today on Sipping Legal Tea? So, very interesting topic. Joint tenancy versus tenancy in common. So you find that a lot of persons don't know what these two terms mean. And so I'm here to try to break it down for you. So when you're purchasing a property or you're leaving a property by way of will, you need to understand and there are two or more persons that are gonna be going on title or you intend to benefit regarding this property. You must understand whether or not you want to leave them with the property as joint tenants or tenants in common. Now let us start with tenants in common. So if there are two or more persons we call co-ownership of a property, you will understand that you can make that decision at the point of the transfer or at the point of preparing the will. Now, a tenancy in common is essentially where you have two or more persons going on title and they have their distinct share. Now, it can be that they have equal share, which is 50-50 if it's two, if it's a third, if it's three or more persons, then you will divide it accordingly equally. But you also have unequal shares for tenants in common. So that essentially means if I am to go on title with my sister, we can either say I have 60% and she has 40% interest in the property. No, that does not mean you will have yellow tape in the middle of the house or part of the house saying this belongs to me and this belongs to her. The interest that we have in the house represents 60% and mine and hers 40%. So in that regard, if a property is to be valued, then what it means is that I will be entitled to 60% and she will be entitled to 40% of the proceeds of the sale. That also means that I can leave my property to my interest, to my heirs. So if my daughter, my son, my niece, my nephews, if it is I own 60% in the property, I can put it in my will to say I want my child to benefit from my legal interest of 60% of the proceeds of this property, or benefit in some way, shape and form. So I can leave a will, I can then transfer it. I can do what we call a gift transfer by gift. So I can transfer my legal interest of 60% to someone else. I can also sell my 60% to somebody else. So it gives me that flexibility to do as I need to. I can also go to the bank and obtain a loan regarding my interest in my 60%. Now, my sister, who has her 40%, has the same right and entitlement to do the same thing that I've just explained. So that is important, that you make a decision as to how you want to own property with someone else. Is it that you both want to own it as tenants in common, where you can leave it in your will or sell it if you desire and you are entitled independent of the other person? Then that might be the best option for you. On the other hand, you have joint tenancy. And as joint tenants, you have what we call the 4 unities. And we often use the acronym PIT, which means the unity of possession. So we all are in possession. You have unity of interest. So we all went on the title with the same interest. Right? Unity of time. So we all went onto the property or the title or the instrument. We gain ownership at the same time. And then you have unity of title, right? So we use the same document to actually gain ownership as joint tenants. But what is most important about the joint tenancy principle is that you have what we call the doctrine of survivorship or doctrine of jus acquiescendi, right? And it means then that when 2 or more persons are placed on title as joint tenants, we no longer have that independent position. If we both purchase a property via mortgage and the mortgage has been paid up fully and it is to be discharged and we are to collect our title from the mortgage institution, did you know that the mortgage institution will not release the title with just one signature? You need both names to request the title, even after you have paid all your money for the mortgage, paid up the loan, cleared the loan, discharged the loan, right? That is how important the joint tenants are to each other in order to transact business. But one of the most important and common questions that we must address today concerning joint tenancy is the fact that you cannot prepare a will without making a specific provision in that will about a joint tenancy relationship. Now, you are not in a position to will your property. It is just not yours only to be willed. And so when you're preparing a will, you must make preparation specifically for these types of incidents or situations where you are a joint tenant. You also may need to do the same thing concerning an account because you are holding the account jointly. So it is a jointly held account. Now, why are we talking about both joint tenancy and tenancy in common? As I've said before, think about it. There might be circumstances you're purchasing property. NHT is providing opportunities for 2 or more persons to purchase a property at the same time. And you need to know, what am I going to be on this registered as on this title? What tenancy? Is it a joint tenant or a tenant in common? And so having the understanding that, listen, I am entitled as a joint tenant 100% to this piece of this pie or this house, and my so is the other tenant. So if it is that we have decided to rent this property, if we do decide to rent this property, we are both entitled to the rents and profits equally. Now, next thing needs to be known, or we need to inform you, is that where there are no words of severance, such as equally, divided, share, and share alike, where there's an absence of those words, it is presumed that this is a property held jointly, or it is jointly held by both parties or all parties involved. So where you don't see those words, then it is presumed to be joint tenancy. And so we oftentimes have persons where there are times when, you may see a title and it doesn't have anything specifically stating whether it's a tenancy in common or a joint tenancy situation, more than it's held in fee simple. Now, What it essentially means is that it is presumed that both parties or all parties are holding the property as joint tenants. And as we said, the doctrine of survivorship, what that means, by the way, is that when one person dies, their interest passes on to the remaining or the surviving tenants. And so that is why you are restricted from doing as you please, restricted from willing or selling or gifting your interest unless you decide to sever, change your tenancy from joint to tenancy in common. So if it is you find that you have an intention or interest to do something specific with your interests separate from the other tenants that are on title, then you must decide this. You must make a decision. You must make a change prior to your death. And that is to change it from joint tenancy to tenancy in common, because upon your death, your interest will pass to the surviving joint tenants. Now, the last surviving joint tenant is the person that is pretty much the sole proprietor, and that individual will be primarily responsible and accountable and in a position entitled to do as he wishes with his property or with this particular asset, whether it is an account or whether it is a house or any land that he is registered as the tenant, the final sole proprietor, the joint tenant, the surviving tenant on title. Now, last but not least, and which must be noted, where one joint tenant passes, there must be what we call a note debt application. So each time a joint tenant passes, it must be noted on title, because as we said before, it is so important, it is so crucial to account for all joint tenants that are noted on title. So if it is that they are no longer around due to the fact of the one of the joint tenants passing on, then in order to do any form of legal transaction with this particular title, it must be noted, and you do this process, you go through this process by applying for a note debt to be registered, which essentially requires you to do an application, submit it at the stamp office to be stamped, and then to the titles office for them to register it. Of course, you will need the death certificate of the deceased joint tenant, right? So I thank you for listening. I thank you for hearing what is being said about joint tenancy. But if you have any further questions, feel free to ask, to inquire about joint tenancy and tenancy in common. But please note that it is important for you to think about the relationship. So it's very important that if you're in a partnership, if you're doing business transaction, you might not want to do a joint tenancy. It is most common among husband and wives and parents and children, where they are looking at a succession plan for their children. So if you're in a business relationship, you tend to find that persons are not so inclined to become joint tenants, right? They'll rather do tenancy common so that they'll have their distinct share so that they can pass on to their own children or pass on to whomever they wish. But think about it, because your situation might be different from somebody else's. And so we leave that with you today on sipping some legal tea. So reach out if you have any more questions or if you have any insights you want to share. Thank you.